bit tardy, and I apologize for being a bit late. I had a meeting this morning I could not avoid. So I believe we're going to start with, before we do the roll call and sort of the standard part of our regular hearing, a work session on Robert's Rules of Order by Kyle Davenport, our Assistant Attorney General. So with that, Mr. Davenport.
Thank you, Mr. Chair. Kyle Davenport, Assistant Attorney General. As our chair just said, this is the first in a working session. It's a staff idea to present topics of interest and things that may be helpful at the beginning of each meeting to yourselves, the commission. We think it's a good idea. We can look at various things that are of interest, and it's followed by a number of other boards, local governments, et cetera. And so if you also, commissioners, think it's a good idea, we will continue to do it. As Mr. Chair said, I'll be covering today some procedural matters. So the good news is it will only get better from here. We assume things will be of much more interest to you and be much more exciting after this one. I'll be covering meeting process as well as commission's procedures. So that includes Robert's Rules of Order. It also includes some various things which are listed on the slide in front of you that aren't necessarily covered by Robert's Rules of Order, but are covered by other things in the commission rules. But we will start with Robert's Rules of Orders and orderly and effective meetings. Robert's Rules of Order are a series of rules that are intended to create a clear record and ensure orderly proceedings. We follow them. Many other boards and commissions follow them as well. The purpose of these rules is really three. I think that is to ensure that you all have equal rights, privileges, and obligations, to ensure that we make a clear record, and to ensure orderly proceedings. Some very basic rules that apply virtually across the board are that no person may speak until recognized by our chair, and that majority vote essentially rules nearly everything, though there are some limited exceptions, one of which we'll discuss a little bit later in regard to calling the question. At this point, I think staff would like me to recognize our chair, Mr. Benton, for doing such a good job at our special hearing on November 28th for recognizing when people are speaking and making it clear on the record what exactly is going on and who's voting. So staff was very appreciative when doing the minutes of you taking the time to do that. And I have to mention, I know this is a little bit of legal dentistry in the sense that it's painful and tedious in some cases, but it's probably a good idea to do it regularly, and it'll probably save us some problems down the road if we follow some of these things as closely as we possibly can. And so I'm going to turn now to motions. The slide in front of you lays out the general process for a motion, and before we get started with that, I'd like to just state again how important it is for, before you speak, to be recognized by the chair, and that can be simply as simple as you raising your hand or saying, "Excuse me, Mr. Chair," and our chair can then say, "Yes, Commissioner, whoever, you have the floor," and then we may proceed from there. But it's very helpful for a variety of purposes if we know exactly who's speaking at all points in time. As I said, this is a quick run through of the motions procedure. The goal here, and this is the goal in anything that we do, but especially on motions, is to make it very clear right from the start exactly what the motion is, and then to make it clear again exactly what we're voting on. And so I think we can all help with that if somebody's not clear. The general procedure is that a commissioner makes a motion, it must be seconded. I want to highlight a friendly amendment that must be accepted by the maker of that motion. So if you think a motion can be improved by making a friendly amendment to it, you may do that. Please do that before debate begins, though. I'd like to also point out that there are a number of rules in regard to debate. We have not been extremely strict in following all of those rules because it really hasn't been necessary, and I don't think we've come close to violating any of those rules. But there are Robert's rules about how long debate can go on and how many people can speak. I think it's a good idea, just in generally, if all of the commissioners take a minute to allow other commissioners to speak after their comment is done. That's helpful. And generally, the maker of the motion is entitled to speak first after they've made that motion about why they like their motion and think it's important. During debate, if you would like to change the motion, you must make a motion to amend. So after the motion is made, no friendly amendments, debate begins. I think in order to be very clear about exactly what we're talking and discussing, exactly what the motion is, so that the motion doesn't just sort of ambiguously morph as we're going on in debate. If you would like to make a change to that motion, you must make a motion to amend the motion, and that must be voted on. And that, again, is just to ensure that we're all being very clear exactly what we're talking about. And I think it's important as well, point 6 specifically, that the motion be restated, clarified, any consequences before you make a final vote on that motion. Also, please, if anybody has any questions, feel free to jump in. Mr. Chair.
With respect to number 6, I presume it's acceptable to have our hearings manager, Ms. Prine, restate that motion also.
That's certainly acceptable.
Okay,
Or myself.
thank you.
I can make a quick point about calling the question. Calling the question is a specific procedural matter. We've sort of been using it as a question to say, hey, is everybody ready to vote now? That's not really its purpose. Its purpose is to be kind of the emergency stop on debate. If any of you feel at any point in time that we're just going nowhere with a debate and it's really time to stop debating and vote, any of you may call the question. That must be seconded before it may proceed, and it should be voted on immediately. This is one of the exceptions to our majority rules guideline. 2/3 of the commissioners must approve that motion to call the question. If it is approved, you vote immediately on the original motion. If debate has reached its natural conclusion and we're just ready to vote, we don't need to say call the question. Our chair or someone else can just simply ask if we're ready to vote. One final point in our meeting procedure, Robert's Rules of Orders, is voting. Again, as always, our goal here is to be very clear. If the vote is not unanimous, my suggestion is that we take a roll call vote just to make it very clear what's going on, and our secretary will run that roll call vote. Recording abstentions, though not required by Robert's rules, I think is an important thing to do as well to make it clear that we do have commissioners in the room who are not actually voting on a particular motion. We're going to turn now to commission procedures, and under this, this is certainly not every procedure that we follow. It's some of the important ones, it's some of the big ones. If you've like anything that you'd like me to discuss that you don't see on that list up there, please let me know as well. Conflicts, I think you're all familiar with that, but we'll go through it quickly anyway. You are governed by the Colorado Code of Ethics as well as COGCC Rule 516, Standards of Conduct. The main idea for both of these, when you're wondering if you have a conflict but something comes up in your mind, it's just like in real estate, location, location, location. For conflicts, disclose, disclose, disclose. You can bring it up in hearing, and if anybody has an issue, they can raise that with you. But if nothing else, you've raised it and you know nobody else has a problem. In regard to the Colorado Code of Ethics, this is what the statute says specifically in regard to your ethical obligations. As volunteers, you have your own special little section in the Code of Ethics. It's pretty small compared to other compared to people who are government employees or hold other positions. You have fiduciary duty. That's essentially the highest possible duty you can owe legally. And you also have an obligation to not perform an official act that has a direct economic benefit on your business or something else in which you have a substantial financial interest. So those are the two statutory requirements ethically. Now we'll return to COGCC Rule 516. This is Standards of Conduct. It provides you guidelines on when you should recuse yourself It states the direct economic benefit from the statute. It also discusses when you may be incapable of making an unbiased decision. And I think what these really come down to is if you feel for any reason that because of the people involved or the issue involved, or maybe you've prejudged the case, that you just can't participate and be unbiased and make a fair decision, it's important to recuse yourself in that situation. There is a forced recusal provision in Rule 516, whereby after a conflict has been disclosed by anyone and the commissioner does not agree, the commissioner against whom the conflict is asserted does not agree to withdraw. If any of you commissioners feel that they should withdraw, you may make a motion in that regard. And after discussion and comments from the public, you may vote on that motion. And if that motion is approved, that commissioner must withdraw. I'd like to turn to the consent agenda now. I think we're all pretty familiar with the process on the consent agenda, but I would like to run through it one more time just to make clear before we get to our consent agenda today. What I want to point out specifically is that under Rule 520, any commissioner may withdraw a matter from the consent agenda. It does not require a vote. It does not require discussion. So I think I'd quickly go through an example here. Let's say in reviewing the consent agenda, you come up with, you can't find a specific bit of geologic or engineering testimony that you think is essential to making that decision on the consent agenda. When the consent agenda comes up for decision, that's the time to ask for a clarifying question. Bring staff up, bring the applicant up, and say, hey, I was going through the consent agenda, I didn't see this, can you give me some information about this? At that point, hopefully the applicant will say, hey, great. We noticed that over the weekend too, we brought it with us, here it is. If that answers your question, you can move on, you can vote on the consent agenda. If you still have issues after that, my recommendation is that you, pursuant to the rule, just remove it from the consent agenda at that point. Say, I can't vote on this right now. I can get more questions. I need to talk about this more. Remove it right then from the consent agenda. And once you've done that, state that on the record. Once you've done that, two things will happen. The applicant presumably still be up here. You'll ask the applicant, can you stay at the end of the hearing and give me more information on this? And then we can talk about it as a commission. That applicant must agree under the rule to hold that matter over to the end of the current agenda for that hearing. If they say, I'm not prepared to answer your question, I don't have my people here, then it should be continued to the next regularly scheduled commission hearing. Does that make sense to everybody? Commissioner Overturf.
Who is the applicant for purposes of the enforcement consent agenda? Is it staff?
There would be parties, I think is the fairest way to say that for enforcement consent agenda, and so bring both parties up and ask whatever clarifying questions you have to both parties at that point. We're almost at the end of, we're almost to 9 o'clock, so I'm going to run through the last two slides pretty quickly. Closing the record is an important procedural matter that happens at the end of a contested matter. To understand what happens at the end of closing the record, I want to make 2 points. First of all, once the record is closed, and it should be formally declared by our chair that the record has been closed, I would like to recommend that the chair ask the other commissioners if they're ready for the record to be closed, because once the record is closed, no more evidence may be taken. You may ask, pursuant to Rule 528, direct questions of the parties, and they may give you those responses. But if there is a huge evidentiary issue that you don't feel has been dealt with and you need more testimony, or there's something really big out there that you feel like you need to talk about more, you don't have to close the record. You can keep the record open, you can continue it. But once the record is closed, the parties can't pipe up and say, commissioners, I just thought of something, or I've got another witness that just showed up and I really want them to talk to you. So it's important to be thoughtful about making that decision on closing the record. And the last thing is public comment. Pursuant to Rule 510, you do have the authority to limit the length of public comments and restrict repetitive statements. I think we can be thoughtful about public comment as well. And for example, we can, at the beginning of public comment, look at how many people are signed up, how much time we have, what the rest of our agenda looks like, and make a decision about how much time to be allotted at that point to public commenters. I know we've traditionally done 3 minutes. There is no legal requirement that it be always 3 minutes. That concludes my presentation. Hopefully I didn't talk too fast. If you've got any questions, please ask them, but I'm of course right there if you have questions as our hearing goes along.
Thank you, Mr. Davenport. Are there any questions or Mr. Davenport from the commissioners?
Thank you very much.
I have a request, however.
Yes, sir.
Being somewhat antiquated, I wouldn't mind a printed copy of that, if you would, please.
Happy to provide one.
Thank you.
Thank you.
All right, I believe we are ready to start our regular general session. Ms. Prine, would you like to start us off?
Sure. Mr. Chair, I'm going to do roll call, and then I need to update you on the agenda.
Thank you.
Commission Chair Benton,
Present.
Vice Chair Holton. Here. Vice Chair Boygan,
Present.
Commissioner Ager,
Here.
Commissioner Hawkins,
Here.
Commissioner Jolly,
Here.
Commissioner Overturf,
Here.
Commissioner Randall, Commissioner Walk. We have 7 commissioners present, which is a quorum, Mr. Chair.
Thank you.
Commissioners, you were provided with a full agenda at your place when you showed up today. You were also provided an abbreviated agenda, and I emailed you an abbreviated agenda. Those two are not consistent, and I just wanted to bring your attention to that. The abbreviated agenda that you've been provided, which is 3 pages, has the correct timing. As you know, as of Friday late afternoon, we had some matters settled, and therefore we were able to push your agenda all to one day. So the full agenda you received has the timing incorrect, but it has the consent agenda attached to it. So instead of providing you all with a full agenda that moves the timing, we just provided you with an abbreviated agenda with the correct timing, if that makes sense. So I will try and keep us on track with the timing based on the abbreviated agenda. Thank you, Mr. Chair.
Thank you, Ms. Prine. I believe the next item we have on the agenda is approval of minutes. And I think, do we have 2 hearings for which we need to obtain approval? Both October and our special hearing in November, is that correct?
Yes, that's correct.
Yes, Mr. Chair, that's correct, sir.
Thank you, Ms. Prine. Perhaps we would just, if there's no objections, we can move to approve both of those together.
Mr. Chair,
Yes, Chair recognizes Commissioner Boygan.
I do have comments on the October minutes.
Okay, then let's separate those out, and we'll start with the October minutes. So you have comments on the October minutes? Please proceed.
On page 11 of the October minutes, there's some language here that I think is a little garbled or confusing. It says, commissioners spoke in depth about their concerns about entering spacing orders that look in location. I don't even know what that means, but I think what it was intending to say was there were concerns about spacing orders that addressed surface matters, because that was clearly the essence of the discussion. Certainly in my mind, that's what we discussed. So I would propose that we change that language to say that instead of saying that look in location, that it would say something to the effect that addressed surface matters or that took into account surface locations. It then goes on to say Commissioner Randall proposed language to resolve these issues. I'm not sure that that was exactly the purpose of Commissioner Randall's proposal, because his proposal was addressed at incorporating the reference to the agreement that was reached with Broomfield about incorporating the locations and pad locations in particular into the spacing order. So it didn't necessarily address the concerns that had been raised by myself and others about addressing surface matters at all in spacing orders. So I would propose changing the language to say something like Commissioner Randall proposed language in response to these concerns, although even that I think is not quite accurate, so I'd be open to suggestions by others. But I think this whole paragraph needs further thinking. It's an important subject, and we've got to get it right.
Thank you, Commissioner Boygan. Perhaps it might be useful if you would like to work with individuals who took the minutes to prepare something, and we could vote to approve those at the next hearing, if that would be a reasonable approach.
We will redraft that portion. If we can get it done by this afternoon, then you could go ahead and approve the minutes
Okay.
this afternoon.
Thank you, Ms. Bryan. I appreciate that. Thank you, Commissioner Boygan, for bringing that to our attention. With that said, we will set aside the October minutes, and we will look for approval of the November minutes.
Move approval of the November minutes.
Commissioner Hawkins has made a motion to approve the November minutes. Is there a second? Commissioner Holton has seconded that motion. All in favor, please say aye. Aye. Opposed, same sign. Carries unanimously.
Mr. Chair, if I may.
Yes, you may.
Kyle Davenport, I think we'd like to note for the record that Commissioners Randall or Wolk are present now, and were present for that vote. Is that correct, Commissioners? Okay.
Yes, thank you.
All right, thank you.
Thanks for the reminder. We now have everyone here. Oh, nice. All right, I believe the next is the report from Executive Director's Office.
Thank you, Mr. Chair. Good morning, Commissioners, members of the audience, and those listening at home, or hopefully not at home, but maybe in their office. I'm going to touch just a little bit on sort of where we find ourselves on the calendar, because this is the time of year at the department level that we plan for next year. And so that includes legislation and budgeting primarily. So just to note, the department will be in front of the joint agriculture committees of the House and the Senate on December 21st for our annual SMART Act hearing. That's where we report on our performance management goals, our performance over the last year, and what we see coming forward in the next year. So that's an opportunity to listen in if you're interested in that. Second, I'll just note, we do have our legislative agenda for the department sort of sussed out at this point, and I'll just touch on those matters briefly, and I'm happy to take any questions on them or talk about them on a break. But this is a sort of an annual process by which we, at the department level, take in proposals from the divisions, we work with them via the executive director's office, and then ultimately move things over to the governor's office to decide what we'll pursue legislatively. So first, this year we do intend to propose legislation to address Colorado Parks and Wildlife's financial sustainability. fees for hunting and fishing licenses provide funding for the vast majority of CPWs, especially wildlife operations, but also on the park side. Or I guess license fees don't fund parks work, but the wildlife fees in particular are set legislatively, and they were last increased in 2005. During that time, our purchasing power, because they're not adjusted for inflation, costs have gone up. And while we have trimmed the budget, our spending power is less than it was 12 years ago, as you can probably imagine. And so we're looking for a bill to give the Parks and Wildlife Commission the authority to set those fees administratively rather than having it go through bill. And there will be a number of other elements on that. Second, we intend to pursue legislation applicable to the Division of Reclamation, Mining, and Safety. This would create a new limited impact mining permit for construction materials sites. So these are sand and gravel operations. And if they are under 5 acres in size, there will be sort of a right-sized permit to ensure that those folks come under the purview of the state regulatory system and in a way that makes sense to see those small sites reclaimed, rather than having to go through the more robust process for larger mine sites. Third, we are looking at legislation to clarify the department's ability to accept and expend gifts, grants, and donations. This is a little wonky, but it exists for some of our divisions, but not all of them. And so we're looking at department-wide the ability to accept gifts, grants, and donations from private parties so that we can spend those funds. We are still working through creation of a voluntary operator-funded program to address abandoned and orphaned wells. So that's something I anticipate providing periodic updates to you all on. This is something that we've been talking with industry about for a long time. And again, we anticipate proposing legislation to address that. And then finally, a couple of our annual bills, the annual water projects bill out of CWCB, and then our annual Species Conservation Trust Fund bill to fund wildlife programs to keep species off of the endangered species list. Those both become a little more difficult because of some budgetary issues that I'll touch on briefly too. But again, that's sort of our legislative agenda. Those are the bills we will proactively seek out of the department in the upcoming legislative session that starts on January 10th, I believe. So then finally, I just want to touch on budget. So we had our staff briefing by the JBC staff analysts last week. We have our JBC hearing. That's department's hearing in front of the Joint Budget Committee of the General Assembly tomorrow afternoon. And a big topic of discussion at the staff briefing was the subject of severance tax. And so I want to touch on that just briefly. Last year, in fiscal year 16-17, as a result of a decision that came out in April or so of 2016, the BP America case, we saw going out the door about $120 million in refunds to severance taxpayers. Those refunds were covered by the general fund pursuant to legislation that passed right at the end of the 2016 session. And of that $120 million in refunds, we believe that it was roughly 2/3, 1/3 attributable to ad valorem offsets, so just regular refunds to ad valorem. And that's the 2/3 part, so about $70 million for that. And then $40 to $50 million in refunds attributable to the BP America case. And just briefly, without doing it total justice, that case clarified that severance taxpayers are allowed to deduct the return on investment expectations for investments they've made in transportation and processing infrastructure. So again, it was just clarifying an existing deduction for transportation and processing. But it was unexpected. That was a case that had percolated through the courts for a couple of years. And so looking forward, the sense from the joint budget, or from the Office of State Planning and Budgeting on the governor's office side, on the administrative side, and the legislative council on the legislative side, was that severance tax revenues this year would be about $150 million. And that would have been up from about $11 million last year net, after all of the refunds I mentioned. But we have now seen, we're 4 months into the fiscal year, and we have seen refunds significantly outpacing revenues for severance tax. And this again was discussed last week at the JBC. And that is to the tune of about $6.5 million in the negative. Again, four months into the fiscal year, we are in the hole by $6.5 million. Again, we don't know how much of that is attributable to ad valorem offsets and credits and how much of it is attributable to the BP America case or the filing of amended tax returns, which taxpayers can do for the 3 years, the 3 taxpaying years previous to that. And so, that was unexpected. We've been getting these monthly reports of revenues and refunds for about the last year, and this, again, we've seen this coming a little bit, but this is worse than we thought. The December 20th forecast is the next kind of official outlook from both from the Legislative Council and from the Office of State Planning and Budgeting. And according to the JBC staff analyst last week, they believe that the December 20th forecast could be reduced from that $150 million by as much as $100 million for this fiscal year. So again, severance tax goes to fund a number of different things. It funds grants to local governments administered by the Department of Local Affairs. It goes to water project loans through the perpetual base account that we administer through the Water Conservation Board within DNR. And it goes to what's called the operational account within DNR that funds both staff here at the Oil and Gas Commission, at the Division of Reclamation, Mining, and Safety, at the Avalanche Information Center, at state parks. And it also funds important grant programs that we administer, like the low-income, or I guess we don't administer it, but others do, the Low-Income Energy Assistance Program, Species Conservation Trust Fund grants, forest health grants, community wildfire mitigation grants, and things like that. And so all of those grant programs are forecasted not to see any new money in the next 18 months, this fiscal year and next fiscal year. And we are trying to work through what it would look like if we didn't have enough severance tax coming in the door to fund our Tier 1 programs, which again are staff and ongoing programs of the divisions that I mentioned. So I share it so that you're aware. I want you to know that we are aware of it and are seeking actively to work through that, both with the Governor's Office and with the General Assembly. But these are some unexpected and unprecedented circumstances with regard to severance tax. It's always been a highly volatile and difficult to predict revenue stream. That hasn't changed. We're just seeing it be more volatile and less predictable than we're used to. So with that rosy news, Mr. Chair, I guess I'm done with my report. I am happy to take any questions that you all might have on those subjects or any others.
Commissioner Boygan.
Commissioner Randall, do you have the sense, I know it's early and you're still trying to figure it out, that this might just be a timing issue? Or is it a substantive deficit issue?
So that's a fair question. I mean, honestly, we have a little trouble. The tax returns are pretty opaque coming out of the Department of Revenue. We're having trouble figuring out what of the refunds are attributable to the court case and what are attributable to special districts in Northeast Colorado taxing operators at a higher rate than they have been before. 87 cents or 87.5 cents of every dollar taxpayer oil and gas operator pays to a local government is an offset against their severance tax liability. And so the higher the local property taxes are, the lower the severance taxes revenue tends to be. And so as for timing, again, the Department of Revenue is able to tell us that they anticipate about $75 million in refunds that are already in process, and I could describe these in a little more detail if you're interested, but over the next 18 months, they expect $75 million in BP-related refunds to go out the door. And again, this reflects operators' ability under state law to file amended tax returns for the 3 previous years. And so it might be timing, but that's not really in our favor. Again, if we see this much, this many refunds coming down the line, offsetting revenues that are already pretty anemic, we've got some challenges going forward.
Commissioner Overturf.
Thank you for that, Director Randall. I wonder if there's significant risk moving forward about the funding that's critical to maintaining our staff and the really important work that they do. I wonder if it would be valuable for the commission to revisit or perhaps visit for the first time, I don't know if this has come up before, the requirement to pay a filing and service fee associated with applications for permits that come into the commission. My understanding is that under statute, we have the authority to charge a fee of up to $200, but that we don't typically use that. So I wonder if that would be a valuable thing for this commission to consider moving forward to provide some additional stability.
I'm waiting to be recognized by the chair so that people know who's.
Sorry, Commissioner Randall.
Oh, that's all right.
I was taking notes.
Thank you, Commissioner Overturf. Thank you, Mr. Chair. Yeah, sure. I think it is something that that the commission could consider. We do have the statutory authority to charge application fees, both for drilling permits and spacing unit applications and other things that could generate new revenue. It's not likely to generate the level of revenue that we are seeing, again, if Tier 1 severance tax operational account programs aren't fully funded. This wouldn't likely make up all of that difference. Another challenge is that we would need to get spending authority from the General Assembly. So there is a timing. If we raise that revenue, again, we can do that administratively, but we can't spend it unless we get legislative approval through the JBC to get that spending authority. I don't know that that is an insurmountable issue. It's just, it could raise a timing question about both when the money comes in the door and when we would be able to spend it. But it is something that's been considered and could be a part of a solution.
Other commissioners' questions? Then Commissioner Randall, I have a question. You mentioned about it was the volatility and unpredictability of the source of funding, and then made a comment briefly about that local property taxes that are set in place by a local government entity producers, then you can use that as an offset against the severance tax. Is that correct?
That's right. State law allows an 87.5% offset against a company's severance tax liability for money that they've paid in a local property tax. And that's been in place for quite a while. And the reason that results in volatility is, and again, I know more about spending severance tax than collecting it, so bear with me, but a company makes the investment and pays the property tax, and that isn't applied to the production until 2 years later. There's a lag in just because of when the revenue is earned and when the property tax is paid, that honestly, I could probably ask my budget director to come over and explain in a way that might be more understandable. But again, I think the point is there's a lag between when they've collected the revenue and when they get the offset. And that leads to again, volatility.
There may be some benefit to that. I'll visit with you about that as a possibility. But essentially, what you're saying is if, for example, the city of Broomfield elects to increase the property taxes to an operator developing Broomfield, then the taxes that they collect, they can offset 87.5% of that against the severance taxes they pay the state. So essentially, there may be more money goes into the local government entity at the expense of state programs.
I think that's probably a fair anecdotal kind of characterization of how it would work.
All right. Thank you very much. Appreciate that. Next, I believe, is the report from the Director's Office. Director Lepore.
Thank you, Mr. Chairman. Good morning, Commissioners, members of the public, those listening online. I have a relatively brief report. You all have a staff report as usual. I will highlight just the first article in there, which talks about financial assurance for excess inactive wells. I touch on this briefly, largely to follow up on Commissioner Randall's comments about orphan well funding and sort of continued efforts to address that issue. The excess inactive well provision of our rules allows the commission to seek additional financial assurance from an operator who has posted a blanket bond when a certain number of that operator's wells become inactive. While it's not a complicated formula, it's a very complicated formula to explain verbally. But I'll just say that the staff has been very proactive for about the last 2 years in following up with operators who do have that higher percentage of inactive wells and seeking the additional financial assurance from them. As a result of those efforts, we do have far larger dollar amounts of financial assurance in the door for certain operators. At the same time, that turns out to be a mechanism by which we sometimes find out that operators don't have the economic wherewithal to follow through on their obligations. So it's been a good program in both of those ways, in increasing the available financial assurance and alerting us to situations that we're going to have to work through. But I do, again, want to raise that just to kind of keep this issue of orphan wells at the front of your minds. I want to also talk briefly about the ongoing sort of heavy workload faced by the hearings unit. We have seen a pretty sharp increase in applications for orders from this commission over the last few months. That has been combined with a hearings unit staff shortage. And the consequences are, I think you feel, in terms of sort of late arrival of your hearing docket and your hearing packet. It continues to be a challenge. I just want to say that we're not oblivious to that challenge and are working to solve it. The staffing issues really go back to a prior budget challenge that the commission faced when commodity prices sank, oil prices sank. That does affect our revenue stream. In response to that, staff voluntarily did not backfill 9 positions as people retired from the commission or moved on from the commission staff. We left those vacancies open. One of those was in the hearings group. Then we had a turnover in our hearings manager from Julie Murphy to Julie Prine. There was a vacancy there for a period of time. And now more recently, Jill Durancy resigned from the commission, so we have another vacancy. We actually now have 2 vacancies in the hearings officer positions. So we are actively working to fill those. Interesting anecdote I won't bore you with about the last person we made an offer to. Apparently they didn't read the salary range description carefully. But in any event, that's one challenge. The other challenge is, I'll just read you some numbers here. You are well aware that a number of matters each month get continued from one month to the next. So if you take those matters that have been continued and then add the new hearing applications that we get, that's kind of our workload for any given hearing. So in September, there were 177 matters to be considered for the September hearing. 93 of those got carried over. We got 122 new applications, so we had 215 matters on the docket in October. 128 of those got carried over, 104 new applications. There were 232 applications on the docket for this hearing. And that pattern continues. We have right now 203 matters on the docket for the January hearing. So that's a heavy load historically. And then the final complication is that a higher percentage of those matters are being protested by an interested party, someone other than the applicant, obviously. Higher percentage that I can remember. We haven't really tracked percentages of protests very closely, but I would say on average, historically, that number has been something around 20%, 1 out of 5. Over the last 3 months, it's been 34%. So more than a third of all matters that are coming in front of us are being protested. So all of those things combine to make a heavy workload for staff, challenges for you, as I've mentioned. And you're also, I think, all aware that it's a very, very dynamic process. So those protests get filed about 2 weeks before the hearing, 10 days before the hearing. And then there's a bit of a mad scramble to see if the protests can be resolved, if the issues can be addressed. A lot of those are the matters that get continued to the next hearing and so on. And as you saw from this docket this month, we thought initially it might be a 3-day hearing. Then we thought we could get it down to 2 very full days. And now, Friday afternoon, one of the larger contested matters settled, and we're down to a single-day hearing today. That's just kind of the dynamics. We don't have a lot of control over operators, who are trying to work those things out, resolving those things, sort of on the courthouse steps, as it were. So, but I wanted to give you that update and background, let you know that we are aware of it. We are working to fill those staff vacancies. That will help a lot, I think. Not much we can do about the protests and things like that, except to try to continue to work through those. A hearing or so ago, concerns were raised about these fines that are being imposed and operators not paying the fines. I guess in many instances, we're able to sort of anticipate because the operators appear to be defunct or at least non-responsive. We sort of have a good sense we aren't going to, go spend that money because we don't think we'll ever see it. And Commissioner Boygan asked about possibly pursuing collections of those. So Hearing Supervisor Jeremy Farron, has been working on that a little bit, and he's going to give you a short update here.
Mr. Farron, if you'd like to proceed, please.
Yes, thank you. If you'll recall, it was a few hearings ago, I think Mr. Davenport offered to sort of investigate what the AG's office could and couldn't do within their budgetary constraints. We did not go very far down that road, and instead what we did was we sort of attempted to get back in touch with the State Office of Central Collections, and I've probably mangled that name, but Central Collections is the name. So there is a State Office of Central Collections whose duty is to collect on debts owed to the state, including enforcement penalties. I've been told at no cost to the agencies, so it would be 100 cents on the dollar. Historically, the prior enforcement supervisor was referring matters to that office sporadically with, honestly, fairly limited success. I've been told that they now have a new director. They may have some tools that would be very attractive to us. And so we're kind of going down that avenue right now. Myself and David Beckstrom from the AG's office have reached out to that office. As of today, we've not been able to get in touch with somebody who can walk us through the nuts and bolts and tell us what tools they can employ. But we're hopeful that we can get some answers fairly quickly, and we'll come back and let you know all about that once we know more.
Commissioner Boygan.
Sure. Thank you. I'm wondering whether another avenue, in addition to that, which is helpful, thank you, would be to pursue some sort of reciprocal communication with agencies like this in the states where these operators are found or have other operations, to see whether there can be some sort of reciprocal enforcement activity, some conditional permit granting if they're still active. I mean, I'm assuming most of them are defunct or you can't even find them. But if some of them are still operational and are just choosing to walk away from their responsibilities here, possibly agencies in other states where they are still active could help in their own permitting activities, their own enforcement activities, by requiring compliance with obligations here. Don't know whether that would be fruitful or not. It might be a waste of time. Maybe there's some kind of centralized communication network among the agencies that could help. So I appreciate that. And then I appreciate you exploring that. And then the notion of chasing folks in other states. Obviously, there's a diminishing returns concept here, and it just may not be worth it in most cases, which suggests that there needs to be more effort on the front end, like, for example, increasing financial assurance where you can, and then exploring other avenues for identifying potential problem areas before they get to that point. Perhaps, as I think was raised in one of the earlier sessions, looking at approving transfers of operations and financial assurance, exploring financial assurance when transfers of operations are filed. So I appreciate the ongoing efforts to look at this. I'm sure there are other tools that maybe we can come up with. And
I will say, I've spoken to my counterpart in Wyoming recently, and he's taken it on himself to sort of compile lists of operators that one state has, foreclosed on their financial assurance, and so we're actively working to come up with, sort of interstate coordination in that regard. So,
Mr. Chair, one more quick
Yes, Mr. Morgan.
observation. That's
Mr.
great.
Morgan.
That's very helpful. Another obvious point here is that operators may be working through affiliated entities or different names, but it may be the same principals who are involved in more than one state. So if there were some way to track that, perhaps as we authorize operators to do business in the state or to become qualified operators, identify the principals and maybe make an effort again to track that in different states. And to require, frankly, that principals take on responsibility if they can't demonstrate that their entities are consistently solvent and able to perform their financial responsibilities here.
all great ideas that we will continue to investigate.
Thank you, Commissioner Morgan. I think appreciate that. That's my comment also, is that oftentimes the principals change names frequently, and being able to come up with a way to track those principals, I think, is also important. I wanted to just briefly comment on the director's report on the hearing matters. I think that as commissioners, I would like to say thank you to the staff for all of these that get resolved before they come before us. I don't think that we recognize how much effort goes in to bringing some of those matters to resolution before they come to us. So I would personally like to thank the staff for the work that they've done, particularly in some of the matters that got resolved before this hearing. So if you could pass that on to the staff, please. I appreciate that.
Thank you, Mr. Chairman. I will certainly do so. I think some of them are in the room. It is a quasi-judicial process, and we're lucky to have some very capable lawyers serving in our hearing officer positions. They are managing a judicial caseload, essentially. Lots of pre-hearing procedure involved with all of these cases that are protested in terms of pre-hearing conferences and scheduling and motion practice and so forth and so on. So thank you for the recognition and appreciate it.
All right. With that, the next item on the agenda is,
Hold on.
oh, I'm sorry, Director
I may, Mr.
Lepore.
Chairman, I had one more point I wanted to make, and then I'll answer questions
Sorry.
if there are any.
Apologize for that.
Thank you, Mr. Chairman. I just wanted to alert the commission. You'll recall at the, let's get my months right here, October hearing, we had a mini November hearing, but in the October hearing, there was a contested matter in front of you involving spacing applications. Crestone Peak had filed certain spacing applications. Extraction, Oil and Gas had filed competing applications. It was a lengthy hearing. You eventually approved the extraction spacing applications and denied the Crestone Peak spacing application. Crestone Peak has filed a lawsuit challenging your decision in district court, so they are seeking judicial review of that final agency action. We were served with that complaint last week. We will be sure to provide you copies of the complaint if we haven't, and it is on the agenda for the executive session this afternoon, but I just kind of wanted to give you all a heads up that Crestone Peak has sued the commission. And that's all I have today, Mr. Chairman. Thank you, and I am, of course, happy to answer questions.
Thank you, Mr. Chair. Yes, Commissioner Walk.
Thank you, Mr. Chair. Quick question for the director on the first item, the financial assurance piece. Does staff have a sense for what the potential liability, the sort of the world of the financial liability looks like? What the then potential sort of bond or financial assurance in total looks like? And if there's a gap, and if there is, what that gap is?
Go ahead, Director Lepore, I'm sorry.
Thank you, Mr. Chairman. Thank you, Commissioner Walk. I think the best answer to those questions that we have at our fingertips is the result of our response to some questions posed to us by Senator Ray Scott. About 2 months ago, I think he submitted the questions in conjunction with Representative Bob Rankin. Dave Andrews, who is our engineering supervisor on the West Slope and who has recently been appointed, chosen to lead our orphan and distressed operator group, which is a cross-unit working group we've put together to respond to these orphan well situations, has done a lot of analysis and run a lot of numbers. The scope of the potential liability is difficult to gauge. We do not have really meaningful, direct economic information about operators. What we have used as a surrogate for that are a handful of criteria, a number of criteria really, for data that we do have. And so an example would be the percentage of an operator's wells that are shut in. If an operator has a lot of their wells shut in, that does not bode well. A second criteria are the number of wells an operator has that are producing at less than stripper well quantities. So we have a defined term for stripper wells, 15 barrels of oil a month, I think. I'll probably get it wrong, staff can correct me. But we can analyze that and we sort of set a threshold of if your wells are operating at half of that rate, how many of those wells do you have? Again, you don't have a lot of revenue coming in if that's where your wells are operating. The third major criteria we looked at were, even if you don't have a lot of your wells shut in, if your wells are shut in, there comes a period of time in which you are obligated to do a mechanical integrity test. So we're looking at past due mechanical integrity tests, right? Regardless of how many of those are, what percentage are shut in, of those shut in, have you done your mechanical integrity test? If not, we assume there's a bit of a problem. Looking at all of that data, in response to Senator Scott, we identified 66 operators out there in the world whose wells meet one of those three criteria, at least 50% of their wells, right? So at least 50% of their wells are shut in, et cetera. 66 operators that fall into that category, collectively operating 4,000 wells. So that's our best estimate of the world of more likely than not future orphan wells.
I'm sorry, how many wells did you say?
4,000. Again, I should be clear, maybe none of those end up orphan wells. But if you're trying to forecast and prognosticate, we thought we'd start there. We ran those numbers a little higher percentages, 70, 80, et cetera. The number of operators shrinks a little bit. The total number of wells shrinks a little bit, not vastly. Okay, so hold that thought. Then Mr. Andrews calculated what does it cost on average to plug and abandon a well, to reclaim a location, and to potentially conduct remediation. Again, you're not gonna have to do that at every single one of these. Some locations have a single well, some are multiple well pads, et cetera. On average, a single well location costs about $85,000 to plug, reclaim, remediate. On average, over the last several years, the amount of financial assurance, bond or otherwise, available to the commission to plug and abandon wells that are known on the books, we've done these projects, is about $7,500. So give or take, there's your gap. Every case is different. Every operator is different. But with blanket bonding, that's why the number is what the number is. And you also have to realize historically the bonding amounts were different. So the existing bonding amount of $20,000 for a well deeper than 3,500 feet, single well, $20,000, that rule took effect in 2008. Prior to 2008, it was half that amount, $10,000 for deeper than 3,000 feet, $5,000, I think, for the shallow wells. Doubled in 2008, has been the same since. So again, every case is going to be different, but if you're trying to kind of look at averages, that's where we are. It's good news day here at the commission.
Great.
Commissioner Boygan?
Mr. Chair, thank you. So, Director Laporte, do you have more direct tools? Can you communicate? Can you ask an operator for financial information under the rules? Do you have the leeway, the latitude under the rules to be more aggressive in how you obtain information? I mean, I think what you're doing is a great start. It obviously is starting to telegraph wells that are on their way to the plugging process, and maybe operators that are struggling. But do you have a more systematic way of obtaining financial information from operators?
Thank you, Commissioner. I guess I would tell you that I believe it depends a little bit on context. So one place where we have been more aggressive in seeking an operator's financial information is where the operator has asserted an inability to pay when we are pursuing enforcement action against that operator. So we're usually in settlement negotiations, for example, proposing penalty X based on our enforcement and penalty policy, and the operator's response is, can't afford it. At which point we say, show us your books. In sort of an a priori scenario, I think our statutory authority is pretty tenuous to say we want to examine your financial health. I would also tell you that I don't really think we have the staff or the expertise or manpower to do that effectively across the board. We have, and I think I've touched on this in the past, we've started to be a little bit more aggressive or assertive when in these transfer situations. So operator X, who's been struggling, decides to try to sell assets. Those assets are often, in this worrisome scenario. And we have expressly, in some cases, said, that's fine if you find a buyer. You need to let the buyer know they will be posting a bond far in excess of the existing $20,000 per well or blanket bond, that we will really look at this as a 707 scenario where we have information to believe that the standard bonding is insufficient, and we will ask you to post additional bond. So those are two specific cases that I can point you to. But generally speaking, I think, the feeling is that there's a regime that exists that provides for a certain amount of financial assurance. If they post that financial assurance, they've met that obligation. And until we get somewhere down the road where we can point to specific details that give rise to that, and I'm sorry, I can't cite the rule 70 something that says with specific information, the commission can seek bonding beyond that amount, then that's where we invoke that provision.
Thank you, Director Lepore. Any more?
Sorry, I don't want to prolong this, but just one
That's
more
all
quick
right,
comment.
Commissioner Boygan.
So there may be some combination of regulatory change and legislative relief that one could look at to try to address this. Financial assurance is one tool, obviously, and potentially a very helpful one. But the more you can look at things on the front end before you even get to that point, or in addition to financial assurance, obviously, the safer you are. So maybe there's best practices in other states, or maybe further thought can be given to how to address this more on the front end. But I think more needs to be done. I think you're moving in a good direction with the tools that you have available, but those tools are somewhat limited.
Director Lepore?
Nothing
else?
further, Mr. Chairman, thank you.
All right, I think the next item on our list is commissioner comments. Any comments from commissioners? or would we all exhausted them during this earlier period? All right. So we'll now proceed to audience comments. I have a few items to mention ahead of time. First, I believe Representative Foote is here today. Thank you for attending, so just wanted to recognize you. Anyone else from the legislature that's here today?
Senator Jones.
I'm sorry, Senator Jones is here today. Thank you, Senator Jones. We appreciate you attending today. We talked briefly early on about the public comment period. I would like to mention again the concept of civil discourse. Last time we had a very lengthy public comment period. As commissioners, we appreciate you taking the time and effort to come here and show up today. However, that said, we also expect civil discourse in these comments. And therefore, we do not appreciate comments in which we personally attack people on the COGCC staff or the commissioners. Will not be tolerated today. If that happens, we will stop this hearing and ask you to leave. I would also request, again, since we have standing room only, I see several people out in the hall, that once you have finished your public comment, please step outside so someone else can come in and have a seat and give them an opportunity to speak. There's been some very patient people standing here today, and we'd like to give them an opportunity to have a chance to have a seat and to speak. So with that, Mr. Davenport, how many people do we have today?
On the sign-up sheet, we have 44 people signed up for public comment.
Thank you. So our usual 3 minutes per?
Oh, I'm sorry, we now have 52, I believe, people signed up for public comment. We have 2 hours and 10 minutes now set on the agenda for public comment, and 52 people.
150 minutes.
Okay, thank you, engineer.
That's 2 hours and 2.5 hours. I think we'll proceed with that. Yes,
Mr. Chair,
Commissioner Randall.
If I could I just suggest we give the opportunity to our elected officials to speak first if they're inclined? Not to put you on the spot, either Rep. Foote or Senator Jones, but if you'd like to speak,
That was the chair's intent, but Director Randall,
Okay.
thank you for reminding me.
you bet.
All right.
Boulder County Commissioner Elise Jones is
Okay, so we'll allow Ms. Jones, if she'd like to speak early also, we'll allow her to come and speak as well. Okay. So I think we can probably stick with the 3 minutes, do our best, and we shall proceed. And I think the usual is we do sort of 3 people at a time, and please ask to please keep be honor of the time commitment here. We do have a lot of people to speak today.
This is, I'm sorry, this is Assistant Attorney General Kyle Davenport speaking. Are our elected officials proceeding first? I don't have them listed in that order. If we'd like our elected officials to speak first, if you could come up and introduce yourself, that would be helpful to me.
Mr. Foote?
All right. Good morning. Thank you. Is this on? I don't think it's on. It is on.
Again, if you please identify yourself at the start.
Right. Thank you. Mike Foote, House District 12, Eastern Boulder County. Appreciate you allowing us kicking this off here this morning. As it turns out, just yesterday I came across an ad funded by the oil and gas industry. And in the ad, the industry shows us beautiful Colorado landscape and claims it engages only in safe and responsible energy production. Of course, nothing was mentioned about the Firestone tragedy or the 12 fires and explosions that have occurred, many of them causing serious injuries and fatalities since the unfortunate Firestone tragedy. And if you were just to look at the industry's commercials, you would have no idea any of that happened. To them, it seems just business as usual. Isn't fracking great? And take a look at our beautiful meadows and landscapes. Unfortunately, it appears that business as usual is taking place at the commission as well. Looking at the agenda, we see dozens of forced pooling applications to be approved, spacing applications discussed, and plans to drill in the middle of neighborhoods advanced. The same could be said for many of the operators that are currently in front of this commission, including Crestone Peak Resources, and I'll have to focus on them just because I only have 3 minutes. But you only need to spend a little bit of time in Erie to know how Crestone is operated. They haven't been around for a long time, at least under the current name, but they have managed to rack up a large number of violations before this commission in that short amount of time. One of those pending violations was allowing complete, non-impeded vending of volatile organic compounds to occur straight into the air just 20 yards away from an elementary school playground. If there ever was a reckless disregard for health and safety, allowing plumes of cancerous chemicals into the air right next to school would be it. Hundreds of complaints have been filed by Erie residents in the last year, and since the state's response to those issues has been inadequate, to say the least, the Erie Town Council tried to address one issue by passing an odor ordinance. Did Crestone do the right thing and actually try to alleviate the odors? No. Instead of fixing the problem, they've sued the town to get rid of the ordinance. A few of those complaints have come from one couple I've known for over a decade. They describe sounds as loud as a helicopter right outside of their house all day and night, wearing masks inside of their own home because of the emissions, and even fleeing the neighborhood for days at a time because their home was unlivable. For Crestone, this appears to be business as usual. Property rights for me, but not for thee. And I'll just make my ask at this point. Crestone now wants to take this track record into eastern Boulder County, but you can stop this. You can send a message to Crestone and other operators saying their blatant disregard for the health and safety of Coloradans is wrong, and you can deny its permit. Please show us that business as usual stops now. Thank you for the time, Commission.
Thank you, sir. Yes?
Also, thanks for the time to testify today. I'm going to hit on two issues. One is the
Excuse me.
operation. Can you hear me? Did I turn it off?
Yeah, and your name also, please.
Okay. Is it on now? Okay. My name is Matt Jones. I'm a state senator representing Longmont, Louisville, Lafayette, and part of Erie. And I see the time's already running. The zero tolerance policy I hope you use with Crestone Resources. They, in their public meeting, showed a wanton disregard for your rules. We brought a letter last time saying this, and they did it again in a telephone town hall. You ought to be doing a notice of violation on that. They broke your rules. They knew it. They're okay with it. And then we find out later that they off-gassed into a school in Erie. This isn't just free speech rights anymore. They're stopped by retired FBI agents at town halls, public meetings. This is people being hurt. One of those things that comes off of there is benzene. It causes myeloid leukemia. I survived that disease. It's a living hell. This kind of behavior is not okay. Crestone Peak Resources now is appealing your violation notice. I can't believe it. They are incompetent to have volatile, toxic, explosive materials. They should not get any permits. And you should fine them for the town hall. Now, you were talking about, I'm going to shift to financials a minute ago. I agree we should be doing this on the front end. Extraction Resources, you ought to look into their financials before you permit anything to happen. They're one decision away, it seems, from the Saudi royal family of making them go into bankruptcy. They've lost money for 2 years. They've issued so many bonds, they've made them junk. They give themselves $50 million, the top two people. And then they want to put these wells near homes. You issued fines around people doing non-performance. You have orphan well issues. You should be doing that up front. These companies should have strong financial records, or you should deny their permit, period. They do not have the money to do what they say they're going to do. All it takes, we saw this 4 years ago, right? The Saudis wanted to drive down the price. They pumped more oil. Everybody went out of business. This company is ready to do that too. So in closing, I respect your zero tolerance. I'm going to finish up on time. Respect our zero tolerance too. Fine Crestone for breaking your rule. I would appreciate a reply to my letter that I sent. I'm glad you're talking to Senator Scott, but I have not received a reply from the letter I gave you from 5 legislators last time. Crestone broke rules, possibly hurt children, and you're going to say okay to more permits? You have that authority. I can't tell you the number of times in the legislature people have told me, don't worry, Matt, the Oil and Gas Commission has plenty of authority to do this. Well, use it. Protect us. These things don't belong in neighborhoods. Find Crestone. Don't let them get away with off-gassing children. And let's do our job in the state and put public protection first over profit of these organizations.
Thank you, Senator. I believe we had a Boulder County Commissioner.
And here I am.
Okay.
Good
ma'am.
morning, everyone. My name is Elise Jones, and I'm a Boulder County Commissioner, and I appreciate the opportunity to speak to you today. I'm here to represent my constituents and share with you their deep and urgent concerns about pending proposals from Crestone and Extraction to drill more than 250 wells in East Boulder County. I was here before you last month. I'm here today, and I will continue to come back again and again in the future, as will, I imagine, many of the people in the audience, until it's abundantly clear and very well understood that the status quo is not working. The process we're going through vividly highlights that the rules and standards that the COGCC has in place aren't designed for the technologies and the concentrations of today's drilling proposals. Instead of a single well drilled in an undeveloped rural area, we're now seeing 20-acre industrial fortresses with dozens of wells sited near backyards and schoolyards, up and down the Front Range in communities one after another. Current rules didn't envision where we are today, and they're woefully inadequate to provide the protections that Coloradans deserve and demand. There have been several governor task forces and rulemaking proposals, and yet none of these have yielded meaningful results in the last few years. Hence, this room full of concerned and angry people. In my years as commissioner, we have received more citizen input on this issue than any other, and there is broad consensus. I kid you not, 99% of the comments that we receive are very clear. They say, keep it out of Boulder County. They say, we are scared of what's going to happen to our children. We're fearful of carcinogenic emissions like benzene and what it might do to their health. We are fearful that there'll be more tragedies like Firestone. We're concerned that the life savings we put into our house is now at risk. I've had many constituents tell me they specifically moved to Boulder County for our clean air and clean water and pristine environment, and that they would not have bought a home there had they known that there was going to be drilling nearby. Indeed, some are making plans to leave. In Boulder County, as in many other communities, some of the sites proposed for drilling are right near schools and homes. We don't allow any other dangerous industrial activities in residential neighborhoods. We shouldn't allow drilling either. Likewise, some sites proposed in Boulder County are open space. We have spent hundreds of millions of dollars of taxpayer money protecting 100,000 acres of open space in Boulder County, hundreds of millions of dollars for farming, wildlife, scenic views, outdoor recreation. 7 times our voters have gone to the ballot to approve taxing themselves, to preserve these lands, not to drill them. The Martinez case ruling holds that you, the COGCC, must make decisions subject to the, quote, protection of the public health, safety, and welfare, including protection of the environment and wildlife resources, end quote. I urge you to follow the Martinez ruling and put public health and the environment first. Thank you.
Thank you very much. Mr. Davenport?
Is that, I believe that's all our
I
elected
believe
officials.
that's
is that
all the
correct?
elected officials, yes.
Okay, thank you. We'll proceed with our standard sign-up list. The first three names on the list are Jamie Jost, and then I apologize, I can't read the next two. The next person's name is Andrew, and then the person following that is, looks like a Great Western representative, so. Sure, please all come up.
You want to go over there? Sure. Andrew, I'll have you here. Thanks.
Again, just a reminder to please identify yourself, and then when you're finished, if you don't mind stepping outside to let some other folks come in. Appreciate it.
Great. Thank you, Chair. My name is Jamie Jost from Jost Energy Law, and I'm speaking this morning on behalf of Nickel Road Operating LLC and Great Western Operating Company to address 6 matters that did not make it on the Commission's final docket agenda published Friday or even in your consent packet today. What we're requesting is that you hear these 6 dockets at the end of your agenda today due to certain issues arising from the 4 dockets for Nickel Road and the 2 dockets for Great Western. The first 4 dockets for Nickel Road are dockets 1710-00734, or I'm sorry, 723, 1710-00724, 1710-00725, and 1710-00726. These applications were filed in August. They were continued to October. Nickel Road worked very diligently to resolve the protests with Cub Creek and Extraction on the dockets, and those protests were withdrawn on November 28th, 2017. Neither Nickel Road nor our office were informed that these dockets would not be on the consent agenda, nor were they informed that they were going to be continued unilaterally to January 2018 without any input of the operator to discuss the needs for these dockets on this agenda. For Nickel Road's perspective, the Form 2 and 2As have been submitted. They've passed completeness, and they are only awaiting approval of these 4 dockets, hopefully today. Nickel Road will be substantially impacted by this continuance as they are waiting for capital deployments for the end of 2017 and early 2018, and they also have an early 2018 drilling schedule that will be substantially impaired if these dockets are not heard today. Mr. Andrew Haney from Nickel Road will speak after I am done to address these issues in more detail. As for the 2 Great Western dockets, this is docket number 1712-00887 and 1712-00888. Great Western has a drilling rig and completions crew on location that will be affected if these approvals are not given today. Great Western actually has email confirmation from both the COGCC permitting staff and hearing staff that these would have been on the December docket, yet they're not put on here. And we absolutely understand the workload of the hearing staff, and we would not be up here requesting these if we didn't have an absolute need to have these heard today. Hal Ryder from Great Western is also here to comment on the effect of the continuance. Great Western and Nickel Road are prepared to present all land, geologic, and engineering testimony today at the end of the agenda. We believe that Nickel Roads can be done within 10 to 15 minutes. Great Westerns can probably be done within about 10 minutes. And we would request that these matters be heard today. And once they wrap up, I do have 2 clarifying questions I need to ask about the consent agenda as listed. So right now I'm going to turn it over to Andrew Haney.
Thank you very much. Briefly, I have a question for the director and our hearings manager.
I'm sorry, Mr. Chair.
Sorry, Ms. Bryan. I'm assuming when we finish the public comment period, we'll have a brief break. At that point, we can have a brief discussion about these matters and determine what we can or cannot do today.
Yes, Mr. Chair.
All right. Thank you, Ms. Bryan. And Ms. Jost, thank you very much.
Thank you for your time today. My name is Andrew Haney from Nickel Road Operating. Our background, we have a team of people that has over 12 years of experience working Colorado assets. So with multiple operators, so we're familiar with the process. We are a small Colorado operator. We hire Coloradans. We did file these matters, these applications in August with the expectation of hopefully being able to develop in early 2018. We very much respect the process. We work diligently to try and cure a lot of matters with interested parties and other protesters to try and meet the deadlines set forth by the commission. Delaying this or continuing these applications to January does impact our business in three specific ways: capital, contracts, and staffing. At this point in time, pertaining to capital, we are not a large operator. These applications represent our business. We don't have a large inventory of locations to go drill. This is what we have. And our capital at this point in time won't deploy until we have regulatory approvals to drill. In terms of contracts, it's a very key time of the year for ourselves as well. We have to try and procure services, and obviously as a small operator, it's very difficult to do that. There's generally larger lead times for ourselves. And early in 2018 provides a very difficult cost environment for us to be able to procure those services as well. Finally, in terms of staffing, we do need the time to be able to hire our technical and operational staff to execute our program, and so a delay in that obviously sets us back. Thank you for your time.
Thank you.
Good morning. My name is Hal Ryder. I'm land manager at Great Western Operating Company. Thank you for your time. On October 23rd, Great Western met with the permitting and hearing staff with the COGCC, at which point we were given the assurances that these two applications would be heard on the consent agenda. At that time, we did act upon these assurances, and we did mobilize 2 completion rigs to conduct these operations, and we're conducting these operations as we speak with these 2 completion rigs. And if we have to stop these operations because our application is not heard and approved today, we will be harmed economically, and I would like to respectfully request that these 2 applications be put back on the agenda.
Thank you very much, Mr. Ryder. We will take that up at the break. Ms. Jost?
One more clarification. Thank you, Chair. I guess I have one more docket. It's 1712-00862. This is a Crestone Peak 640-acre drilling and spacing unit, which is a very simple request for approval. Crestone Peak has requested that we also have this heard at the end of the agenda today. That will likely take no more than 5 to 10 minutes to walk through this. They have stated that the need for approval is based upon their ability to confirm the drilling schedule in early 2018, potentially even in January. So that would be another docket we would request to have heard today. With all these unprotested matters, I do have copies of everything from the agenda to the draft order that I could hand out at our first break if that is something that would be requested by the commissioners, and in order for you to have any appropriate time necessary for review for later this afternoon if you choose to put those on. And then one matter of cleanup for the consent agenda. In Group F, docket number 1712-00831 is listed as ConocoPhillips, and this should be a Great Western docket. And then in Group G, docket number 1712-00843 and 1712-00844 also say ConocoPhillips, and these should just be listed as Great Western. I just wanted to make that clear as we moved into the consent agenda later today. Thank you very much for your time and consideration of these requests.
Thank you.
Excuse me. What was the second
Commissioner
one?
Jolly?
I'm sorry?
What was the second agenda?
1712-00843, 1712-00844.
Correct.
And that was in Group G, I believe.
Yes, the second 2 were Group G, and the first one, the 831, was Group F.
And they should be listed as ConocoPhillips, not Great Western Oil and Gas, or
They
the other
should-
way around.
other way
Sorry,
around.
other way around. Great. Good thing you're keeping me on my toes.
Thank you very much.
Okay, let us proceed.
Janice Brown, Mary Reynolds, and Bob Reynolds.
Thank you, Mr. Reynolds. Thank you, Ms. Reynolds.
Then we have Janice Brown, Brian Wilson, and Lee Snett.
Good Good morning. My name is Janice Brown, and I live in Inglewood, Colorado. I was going to start today by listing the deaths and injuries caused by the 12 explosions and fires, but I've decided to move on from that. I have questions for you regarding health and safety. The governor promised that this detail would be attended to, and it doesn't seem to be happening. To the point that Colorado Front Range family living near oil and gas facilities remain worried and have joined protector groups to protest industry expansion near people. As a retired registered nurse, I am concerned you are not taking the threat to human health and life into consideration when you approve drilling permits near where people live, do business, and go to school. The environmental impact seems to be completely ignored in your permitting process. We live in an arid climate, and in general, it requires 2 to 8 million gallons of water to frack a well. Some wells consume much more. A well may be fracked multiple times. Each frack increases the chance of chemical leakage into the soil and local water sources. The fracking process results in high methane leakage, a superpotent greenhouse gas, as well as nitrogen oxide and volatile organic chemicals, which in the presence of sunlight form smog. I haven't even addressed the benzene problem yet and the fact that it causes cancer. I am extremely concerned about the health of our Colorado community.
Brian Wilson, Lee Snett, and Nina Snett.
Go ahead.
I'm Brian Wilson. I live in Boulder County, just inside the north boundary of the comprehensive drilling plan area proposed by Crestone Peak Resources. I came prepared today to advocate for moving well sites from the northern area along to the Highway 52 corridor, which I think is a more appropriate location. I understood when I arrived today that Crestone is considering doing that now, so I'd like to commend that. My background, I'm a retired structural engineer, worked most of my career for large oil corporations, both upstream and downstream. I'm looking for the best option that we can get in our neighborhood. The approach of putting it on Highway 52 doesn't eliminate all of the risks associated with the drilling operations, but it will help minimize them, I believe. I prepared some satellite photos and annotated them with the number of residences near both the originally proposed pads in the first, second draft that Crestone prepared. Now, if they are moved to 50, I also have alternatives for Highway 52 shown there. And there's fewer homes affected if you move them to Highway 52. So I think that's all I have to say. I had more material, but hopefully that is negated now. I would like to say that I would love to see another draft of their proposed comprehensive drilling plan. They've done 2. Now it's changed. I'd like to have the opportunity to comment on that in the future. Thank you.
Thank you, Mr. Wilson, and thank you for your input and for providing this to us.
Mr. Chairman,
Yes, Director Lepore.
if I may, thank you. So we do have a recent updated proposed plan from Crestone Peak for the CDP, and we have a couple of details to finalize, but full expectation is that that most recent submission will be released to the public as a third preliminary plan or second amended plan or something that the public will have an opportunity to comment on and Crestone and the commission received those comments before Crestone finalizes their CDP. And I guess I'll go out on a limb here and say that your information is correct, that the most recent submission shows all of the proposed pads along the Highway 52 corridor. So hope I'm not getting ahead of the game a little bit, but that's the best information I have.
Great, thank you.
Thank you for comments.
Mr. Chair,
Yes, Commissioner Boygan.
could I just follow up with Director Lepore for a minute? What is the process for this CDP, both in terms of the commission permitting process and just in general, the administrative process? How's it actually, what's going on?
Go ahead, Director Lepore.
Thank you, Mr. Chairman. Commissioner Boygan, the process that we've been following is posted on the commission's website, and it's laid out there. In a nutshell, the process is that an operator proposing a CDP presents that to the staff, the director. If it meets my standards, I present it to you for consideration. The commission first heard this, I don't know, June or maybe prior to June. In terms of the operators that are involved in Crestone, so I can't get into it all in detail right now, but it's all on the website.
Commissioner Boygan.
Director Lepore, thank you. I appreciate that. I understand that it's on the website, and I also understand that if you approve the CDP, and then if it comes before the commission and we approve the CDP, then that expedites or effectively grants all the Form 2s and 2As that are contemplated by the CDP. Is that correct?
Go ahead.
Once the CDP is final and I take it up, and when I say I mean staff, of course, it is anticipated that Crestone, as the applicant for the CDP, will essentially simultaneously be filing location assessment applications and drilling permits, at least the location applications. The commission would consider the CDP, I think, separately from the Form 2As. I mean, the Form, your approval would be of the CDP as it is proposed, including the locations proposed.
More questions? Commissioner Boygan?
Yes. So when would the public have the opportunity to participate in that process?
If I may.
The public has been participating through public meetings held by Crestone Peak and through written comments on 2 different stages of the application thus far, and a third opportunity that I just mentioned, and a fourth opportunity based on the final plan submitted. So there is a web-based portal for the public to comment on each draft as it comes in.
It's a fairly extensive process for a comprehensive drilling plan. That's why no operator has yet to undertake it other than Crestone at this point.
As a matter of clarification, my question was directed toward public process here in front of this commission. I'm not clear on whether this public portal is a way of promoting dialogue between Crestone and the public, which I agree is critical and has to be done. But I'm asking, what is the process here for obtaining and addressing public comment in front of us?
You will have that opportunity when it is in front of you, if it gets put in front of you after, with my approval. So that you will have a public hearing on that CDP application. And there will also be public comment, I should say, individually on the Form 2As. And, yeah.
And I presume, Director Lepore, that any public comments that's through the portal, we have the opportunity to go and read all those public comments too as part of the process.
Correct.
Thank you. Anything else? As we move on, we have a gentleman who's been standing here for a while.
It's okay. My name is Lee Snett. I live on Rodeo Drive in the north end of the Crestone CDP proposal. My comments were written yesterday, and I became aware, as Mr. Wilson did, that a new proposal has been put forward to Crestone, honoring our request to consider revising the proposal to move the pads to Highway 52. And I want to commend Crestone and the commission and their role in it that they listened to our complaints and our concerns and our suggestions from all the groups that were involved and are modifying that proposal. So I'm going to abbreviate some of my comments there. Just reassert, we think that reduces the impact of these pads, these large pads. It does not eliminate them. Brian Wilson's data that he just handed out, based on just the 2 pads that are being moved, shows a reduction in residences within 2/3 of a mile from 62 residences down to 16 by moving 2 hypothetical positions that he came up with on Highway 52. So the difference is significant, and I'm glad Crestone has taken that under advisement. I would like to kind of re-support Commissioner Elise Jones' statement that we must have the best management practices put in place, even though they're moved. I think the rules that she referred to, many of the rules need revision. They have not been updated to account for the large pads moving closer to residential areas. Even with the pads before the revision of the proposal near us, we would have seen something, where I am, I'm a half mile from one of the pads, we would have seen an increase in noise level of 500 times. Some people are a quarter mile from those pads, and they would see a noise level increase of 1,000 times if you would hear, and this is nighttime noise levels, if you would hear the 75 decibel rule for dBA at night. Those are incredibly large increases over what we experience in the area now. And so I think these rules need to be revised with the size of these pads. And the size of the pads has a lot to do with the duration of the construction and the noise. We're talking about 2 years for one pad in this case. So these are, I'm going to skip quickly to one. I'm glad there's going to be revision in a 3rd draft. Thank you for that. We need to look at that again. Quickly, I want to also give my support to Boulder County for a request for a public forum on the 8 North application, which is close to us as well. It's just on the north side of Oxford Road. It's possible a pad that 8 North Extraction builds there is closer to us. And if I can just build one question on Commissioner Boygan's request. It is unclear to me, reading what's in the plan, what the dependencies are between the Form 2s and 2As and CDP are in terms of timing and approval. It's simply unclear because Crestone has stated that some information will not be developed until they create the Form 2As. But is that happening after the CDP, after the commission hears the CDP, before? I think that still needs to be cleared up, what those dependencies are exactly. And so that the proper comment periods are allowed before any approval takes place, really, that all information is made available. That's it. Thank you.